a fifth grader, and his teacher.
A middle school teacher who admitted to kissing her fifth grade student, a boy who was just 11 years old, will now spend her Christmas in prison. Madison Bergmann appeared before a judge to hear the decision about her punishment for sexual misconduct. We're taking a closer look at what the victim's father had to say on his behalf and Bergmann's behavior in this latest court hearing. I'm Angenette Levy, and this is Crime Fix. Have you ever wondered how we are able to share so many clips from breaking news cases as they're unfolding? Well, here's a little secret. Opus Clip is an all-in-one AI editor that makes it a breeze to cut, create, and upload videos across any platform. Through AI, Opus Clip generates B-roll, it reframes footage, and even cleans up audio. Just visit opus.pro/crimefix, sign up, and upload, and within minutes, you are going to have perfectly edited clips ready to go. For TikTok, Shorts, or Reels, it's a one-stop shop. Having Opus Clip means our producers can post viral updates instantly. This is the most powerful tool for sharing ideas and editing like a pro. So go to opus.pro/crimefix to create your videos today. Back at the end of September, 26-year-old Madison Bergmann took a plea deal in a St. Croix County, Wisconsin courtroom. She agreed to plead guilty to 3 counts. 1 count of child enticement, and 2 counts of sexual misconduct by a teacher or member of school staff. In exchange, prosecutors agreed to seek a sentence of no more than 12 years in prison. Well, on Friday, December 19th, Bergmann sat before the judge in an orange jumpsuit where she heard details about her punishment confirmed for the court record. Now, before we dive into the specifics of Bergmann's prison sentence, I want to give you a quick recap of how we got here, and I'll warn you, the details are incredibly disturbing. Madison Bergmann was a 5th grade teacher at River Crest Elementary School in Hudson, Wisconsin. She was engaged to be married. Life looked pretty good, but then it all came crashing down around her in May of 2024 when a young boy's parents brought printouts of texts between their 11-year-old and his teacher. Texts like this one, which was included in a criminal complaint against Bergmann. The victim said, "Ha ha, bro, I just want to make out with you." Bergmann said, "I do too, like all the time." Bergmann wrote, "Also today, when you said, 'I know you're mad, but I want to kiss you,' oh my gosh, I wanted to grab your face and just push you to the floor and make out with you." The victim wrote, "Ha ha, for real, I love to kiss you on the ground too. Ha ha." Bergmann wrote, "I almost kissed you when you were on the ground today, but I got distracted by your stomach." Those texts were apparently in reference to the first time Bergmann had intimate contact with the boy. According to a criminal complaint, when the other kids left the classroom, she approached him and kissed him on the mouth. He described himself as sitting on the ground immediately after the kiss, as he couldn't believe that it happened and the fact that it was his first kiss. He then got up, gave Bergmann a hug, and left the classroom to catch the school bus. According to the complaint, the victim admitted he and Bergmann had kissed several times and touched each other in class, but in a way that no one could see. A school resource officer testified during a preliminary hearing last year that Bergmann and the 11-year-old shared more than 30,000 messages with one another. They also wrote love notes to each other, which police reportedly found among Bergmann's possessions when she was arrested. In one of those letters, police say she wrote, "One of my cousins is in the 5th grade, and I can't imagine a man talking to her how we talk. I know we have a special relationship, and I do love you more than anyone in the world, but I have to be the adult here and stop." At first, Bergmann denied all the allegations against her, but earlier this year, she changed her plea, agreeing to admit her guilt on 3 charges in exchange for a possibly reduced sentence.
Ms. Bergmann is going to enter pleas of guilty to count 3, child enticement. There is a lifetime supervision of serious sex offenders. Enhance her on that at this time. She's also admitting to that. Count 6, sexual misconduct by school staff, and count 8, sexual misconduct by school staff. Based on those pleas, the state is moving to dismiss but read in all of the other counts for purposes of sentencing. We are jointly recommending a PSI be done, and the state is to cap their in-custody recommendation at 12 years at the time of sentencing.
Bergmann teared up during her plea hearing and full-on sobbed, I'm telling you, during the sentencing. The father of the 11-year-old victim, who is now 13, spoke on his son's behalf.
My son actually asked that I read this, so I apologize. My subject to get this in the right spot. So my name's Tico, and I'm the father of the victim. And trying to capture the breadth and depth of the damage caused by Madison is impossible. There's no way in a few minutes to really fully convey how far her actions have reached into my son's life and into our family's life. But I will do the best to give a clear window into what we now live with every day. So since this happened, my son was just kind of a normal kid, doing normal kid things, playing sports. But now he has to live with the consequences of her decisions. He faces things where he gets bullied at school on a regular basis. And then, over a year later, they whisper as he walks through the hallway, says, "Is that the kid? Oh, is that the kid that got his teacher in trouble?" These are the types of things that this 11-year-old has had to deal with. And then he had anxiety, and he's had to go to counseling for that. So anxiety, nightmares, constant stress, constantly wondering, where did his simple childhood go? And even most recently, and the thing I wanted to underscore too is like, this isn't a past tense thing. This is the last 7 days. I'm not going to go into this ad nauseum, but just that I want to kind of convey the everyday impact. So we go to basketball practice, it's scheduled. All of a sudden we look at the schedule, it's the schedule at River Crest Elementary where he went. The last time both he and I were there was the day Ms. Bergmann got taken out of the school, right, and pulled out of there. So very triggering, but then as a dad, I have to ask him, again, are you okay having practice there? I've got to trust his judgment. I have to then think about, do I ask the coaches and give them a heads up? Because this isn't something that we necessarily want broadcast in our small community, right? And then the next day, he's kind of off. And then I'm like, is it because he's just a kid? Or is it because something was triggering for him? I mean, so there's this whole cascade of things that you would think like, oh, we're going to basketball practice. And it gets exacerbated by this. And this was last week. This wasn't, right after. These things still come up. And then, I reread the text, right? Because I have access to all these things too, because they're on my son's phone. And the thing that to me is like, about all this and why I wanted to say something, or my son wanted me to say something, is, in his own words, he's like, I have to live with this forever. He's like, whatever punishment she receives should be forever. Right? I mean, he doesn't necessarily know what that means, right? The whole context of it. But again, when I reviewed the text too, it's very deliberate. Talking about touching his leg, talking to my 11-year-old son about her period, talking about his erections. I mean, like very, very, to me, it's like very, very disturbing stuff. It wasn't like a oops, like a fleeting thing. It was over a window of time and only got intercepted by parents that kind of cut it off. And so that's the other part in looking at like, what do we want out of these things? And so what I was asking for, humbly and respectfully, is that we impose the strongest sentence that you believe is appropriate, including the maximum amount of time of confinement that's possible. And only you can determine what that is. But I think the sentence has to reflect the seriousness of the harm. We have to protect other children in this community, and then recognize what's also been taken from my son, because this will follow him and the family for the rest of our lives.
Judge Scott Norstrand also asked Bergmann if she'd like to give a statement.
Your Honor, thank you for the opportunity to speak. I want to begin by expressing my deepest and most sincere apologies to the Huber family. I am so very sorry for the pain and stress that my actions have caused. There is no excuse for my mistaken choices and my mistaken actions. I want to make it absolutely clear that I take full accountability for every boundary that was crossed. I hope that your family has been able to begin to heal and find some peace in your lives again. I know the journey will be long for your family as well as mine. Your Honor, I do believe in the justice system and people being held accountable for their mistakes. I believe that looks different for every person. And in my case, There's not only the current punishment of being incarcerated, but many lifelong punishments to come. I have lost the teaching license that I studied and worked for 4 years. I will never again be able to pursue my passion of working with children in any sense. I will be on the sex offender registry for the rest of my life. This is going to greatly impact the future I had envisioned for myself, including having a family and children of my own, new and different career paths, and even buying a home or deciding where to live. I fully understand and accept this consequence, but I also ask the court to recognize how profound and life-altering it already is. It is a daily reminder of the impact my hurtful choices have had on others, and it will remain with me for the rest of my life. Additionally, because of the worldwide media coverage of my case, I will be facing ridicule from strangers and friends forever. The media coverage has not only already affected my life and feeling of security and safety, but also my entire family's. My name is in connection to our family business, which has led to online harassment of not only me, but my whole family and their means of making a living. Before being arrested in May of 2024, I was in a deeply unhealthy and emotionally abusive relationship that caused me to become isolated from friends and family. I allowed that emotional vulnerability and isolation to cloud my judgment and alter my ability to process the reality of my inappropriate and harmful decisions. However, Your Honor, since then I have begun to find healing and growth for myself through being back in the safety and support of my family, as well as participating in talk therapy and sex offender therapy. Lastly, Your Honor, I would like you to consider the time that I spent in the community on bail. Excuse me. During that time, I was compliant with every restriction placed upon me, including not having contact or communication with my 3 younger step-siblings for months until it was approved by the court, not having contact or communication with anyone under the age of 18, which includes all of my cousins. I also remained off the internet, had no phone, and had no online or phone contact with anyone other than my lawyer for 17 months. I also stayed within the radius I was given while on and off of GPS monitoring. I'm not seeking to avoid punishment. I'm already facing lifelong consequences, but I am asking for the opportunity to prove that I am willing and wanting to be a productive, law-abiding member of society. I will never be able to undo the damage I have caused, but I'm committed to doing everything I can to ensure that I never harm another person. Thank you, Judge Nordstrom.
The judge addressed some of the prior statements and gave his thoughts on Bergmann's actions. He also discussed some of the most twisted texts that Bergmann and the boy exchanged. It gives us some insight into what was going on, and I have to warn you, it's really, really hard to hear these, especially when you think about the vulnerability of this 11-year-old boy. He was just 11.
Now, one could easily minimize the gravity of these offenses and make, I think, an effective argument to a limited degree that there was not the level of sexual contact, I think, Mr. Gambarino, that you were talking about in these other cases. And I think that's a fair argument. That, however, has to hold up against the other reality in this case, and that is what happened here. It's not the same. It's not like many of those other cases. It's a different kind of terrible, frankly. So what do we know about the facts? We have an 11-year-old boy, a 5th grader, first contact with the defendant as a 4th grader, I think. That's what was reflected. the contact, the personal contact is happening in school, and it began to increase during his 5th grade year when Ms. Bergmann became his teacher. She was even surprised that he was assigned to her class because there was some concern about them being friends before that 5th grade started, but nonetheless he was. First message, I should say, emails that exchanged between the two were from November 29 of 23 to October 29 of 23, according to the investigating officer. There were 34 emails, and nothing untoward specifically, but nothing about learning, or I think that's the way the officer referred to it. Nothing about learning from the teacher to this student, the 11-year-old. Then, a couple of months go by and we get to December 26 of 23 for the first message. The last message I saw was from about April 29. Total text 35,429. So between those dates, I did some math, Ms. Odden, and I came up with about 125 days or 283 texts per day. This is ridiculous on its face. Now, I'm a 67-year-old judge, so I may not text like some, but this level of contact between a 24-year-old teacher and an 11-year-old student going to an elementary school here in Hudson is unbelievable. And then when you start reading what's in the text, we've seen a lot of the details. I don't want to go through that, but I do want to just list off some of the topics that were discussed over time that I identified. Touching each other, kissing, pushing against each other, touching the victim's chest, feeling heart beating, physical characteristics of each other, dreaming about each other, female sexual arousal, female menstruation, devices used for sexual arousal, licking body parts, touching victim's stomach, the victim's own sexual arousal, touching legs, expressions of love. I'm so in love with you. I see you in the morning. This is crazy, in a sense. I don't know why she did this, why she did it for so long, why she continued to bring up new and more salacious details to talk about with an 11-year-old boy. I don't know what level of supervision will be necessary to prevent her from doing this again. We have varying opinions about the need for incarceration, about as varied as they can be. 12 years, 1 year. But I will say this, for purposes of my conclusions here today, I do believe incarceration in the Wisconsin prison system is necessary to protect the public.
The judge also talked about an evaluation submitted by an expert on psychosexual behavior. It was included as part of the pre-sentencing investigation report.
The PSI writer says, Ms. Bergmann reported all of the things she and E.H. said to each other in their text messages did not actually happen. She said they pretended those things did happen, but she was texting the victim on how she wanted her significant other, I'm not going to use the name here, to be with her. The defendant indicated she dissociated when she texted the victim and was thinking of an adult, specifically the fiance, when she sent the victim messages. Ms. Bergmann stated the messages were things she wanted the fiance to do to her and how she wanted the fiance to act toward her. The defendant reported the sexual contact that she and the victim discussed in their messages did not occur. She stated they kissed each other only on the cheek and were creating a fantasy in their messages. Right after reading the text to you, or some portion of the text, obviously, the PSI writer says the defendant indicated she does not remember sending them and felt lost and isolated from her family at the time. She stated she was looking to feel wanted and was not getting that from her fiance. Ms. Bergmann said she's not sure how this situation with the victim occurred and would never say any of these things she said to him to someone her own age. The defendant reported she felt stupid and like a pushover at the time, but the victim told her it was not a big deal and to keep exchanging messages with him. Now, this is all completely backwards. The adult in the room is telling the PSI writer that, I was kind of a pushover to the 11-year-old. So I kept texting, I kept messaging, I kept talking about inappropriate things. Anyway, I just wanted to express my concern about this sort of devolving into fantasy situation when it comes to deliberate, specific, sexualized texts for months, hundreds of times a day to an 11-year-old boy. It's a fantasy, and I was thinking about my fiance, not good enough. The last thing I'll say about that was, when I was reading those texts, honestly, I couldn't tell who the 11-year-old was sometimes. I know that sounds crazy, but both sides of the text messaging seems like an 11-year-old in the behavior that was going on there. The sheer quantity and lurid content of the defendant's text belie any concern for the victim. Her position of trust, her school, her community. It was intentional, deliberate, purposeful. What was the end game? And I think Ms. Otten alluded to this. Where were we going with this? I suspect something much more serious. That's not to say we aren't here for very, very serious criminal behavior, but I suspect that it would have gone farther had it not been stopped by the parents. And there likely would have been a physical relationship that would have resulted in much, much greater harm to the victim in this case. What I saw in those texts, and I'll conclude here on this topic, is an exercise of control by a 24-year-old woman who should have known better, and for reasons I don't understand, continued to do this for months on end, despite her consciousness of guilt.
According to local reporters in the courtroom, Bergmann started crying the moment she entered the courtroom, but when the judge confirmed she would be going to prison, Bergmann started bawling.
While we are here today and are extremely frustrated and concerned about these facts and this case and the terrible impact that it's had, I also have to be mindful that there are cases even more extreme with defendants who have long records of that kind of behavior. And in that light, I think that a more appropriate sentence, and the sentence that I will hand down here today, is I'm going to order that Ms. Bergmann be incarcerated in the Wisconsin State Prison System for 6 years, and that she serve 6 years on extended supervision thereafter. That's on count 3. With regard to counts 6 and 8, I'm going to order 1.5 years of incarceration on each. That's the maximum sentence. And 2 years of extended supervision on each. And I am going to run all of this concurrently. I think essentially the outcome here is 6 years in the state prison, 6 years of extended supervision is an appropriate sentence given everything I've heard here today and everything I've discussed with you. Now, Ms. Bergmann, you're going to have to calm down for a minute because I have to give you some warning. All right?
So according to the plea deal, Bergmann will spend 6 years in prison, followed by another 6 years of what's called extended supervision. And there are lots of rules that Bergmann has to follow when she's out. For example, she's not allowed to have any contact with the victim or any of his family members. In fact, she can't have contact with anyone under the age of 18 without prior approval from her case officer. The conditions also state that Bergmann won't be allowed to use the internet or any kind of social media without permission. She also has to register as a sex offender, and she owes more than $1,000 in court costs. And in a bizarre twist, Bergmann isn't the only River Crest Elementary teacher to be accused of sexual misconduct. No. When all the details about Bergmann started coming out, another 5th grade teacher, Abigail Faust, resigned. Bergmann's alleged victim told police that Faust knew about what Bergmann was doing, but didn't try to stop it. That boy also revealed that Faust also had an inappropriate contact with a student. Faust was charged in St. Croix County with failure to protect a child, causing mental harm to a child, child enticement, and sexual misconduct by school staff or a volunteer. And her alleged crimes spanned at least 2 states. As news of those charges spread, a family in nearby Washington County, Minnesota, just across the state line, realized that was their nanny. That's right. This family had actually hired Faust back in 2021 to help watch their children, reportedly a baby who was only a few months old, a girl who was around 9, and a boy who was 15, when he claims Faust started sexually abusing him. Unbelievable. When the family realized that Faust was being accused of disturbing conduct with minors, they contacted police. The teen's son, identified as victim 1, sat down with the detective for a forensic interview and divulged sick details. Quoting from her criminal complaint here, later, as her sexual abuse of victim 1 escalated, victim 1 recalled Abigail framing it as, "You know, this is bad. I know this is bad, and we'll both get into trouble if you tell anyone." When the two exchanged nude photos on the Snapchat app, he recalled her messaging him, "I can't believe I'm looking at a picture of a 15-year-old's genitals." He remembered her also saying through Snapchat, "I'm feeling grossed out at myself." Victim 1 recalled many instances where Abigail would, in summary, voice to him her realization that she was doing something improper. Charges were filed against Faust in September of 2025. According to court records, it appears Faust's parents helped her post a $200,000 bond. As part of her bond conditions, she is forbidden from having any contact with the victim and has to wear a GPS monitor and cannot leave her home without permission and cannot use the internet, with the exception of virtual court appearances, meetings with her lawyers, and virtual medical appointments. It's unclear when Abigail Faust will be in court next. So I want to bring in Marian Bracha. She is a former sex crimes prosecutor, also a professor of law at the Beasley School of Law at Temple University. So Marian, thank you so much for joining me. The sentence, I'm a little surprised by it. I am and I'm not. 6 years in prison, 6 years supervised release. I feel like a lot of times with these female teachers, we see sentences that are more lenient, maybe no jail time, no prison time. Why do you think the judge in this case said, no, you're going to prison?
Yeah, and it's surprising because this was a guilty plea. So a lot of times there will be some consideration given to the fact that a defendant has has waived their right to a trial, has waived their right to have all the charges proven against them beyond a reasonable doubt. And there is some consideration given to the judicial economy and the system utilization of not proceeding with a full trial and having to call the victim to the stand and having to impanel a jury. So the fact that jail time was issued is certainly within the discretion of the sentencing judge, so long as it is an available penalty as envisioned by the statute. But this judge, after having heard the facts of the case and after having heard the victim impact statement, exercised their discretion and did, in fact, issue a jail sentence. So I don't think it's an illegal sentence. It's within the statutory maximum of what could be imposed. But you're right, it is somewhat surprising that ostensibly a first offender or first-time offender would get a lengthy state sentence.
You know, a part of me wonders if the sentence is sending a big-time message. Also, you know, this was an 11-year-old child at the time. We're not talking like a 16-year-old, and there were 35,000, I guess, messages sent. I mean, this was an 11-year-old. I mean, I know my son is 10. I would come unglued. I don't know how I just would be so upset. I just can't even imagine. I'm like, you are a young woman in your 20s, like early mid 20s, and you're sending all these messages to an 11-year-old. So does that are those like major red flags? If you're a judge and a prosecutor, you're like, this isn't like a teenager. That would be very wrong too. That would still be wrong. This is an 11-year-old.
Well, I agree that the age difference and that the age of the victim is taken into consideration. I think that goes into kind of that discretion that we talked about, the discretion that is within the sentencing judge's power to exercise. Oftentimes in sex crimes cases and in sexual offenses, there is an evaluation that is done pre-sentencing, mental health evaluation, substance abuse evaluation, and something that, at least in Pennsylvania where I practice, is known as a sex offender assessment board evaluation or an SOAB. I am confident that there is a similar or an analogous evaluation that is done in this teacher's home state. And so we have to remember that we haven't, at least I haven't seen the feedback that came from that assessment, how the defendant presented herself at that assessment or, with those members of the assessment board. And that documentation, the content of those pre-sentencing evaluations is also taken into consideration by the sentencing judge. So there must have been something particularly egregious, either limited to or in addition to the age difference between the parties here, the defendant and the victim, but something certainly was egregious enough to depart from, again, ostensibly a first-time offender and give such a lengthy prison sentence.
I'm hoping this little boy, he's a little older now, I guess, a couple years older, but I'm hoping this kid is getting the help that he needs, because basically in a victim impact statement, this child said, you basically ruined my childhood. I mean, you're an 11-year-old kid and you're getting messages like this. You may feel like ick factor and stuff like that, but we know that a lot of times they feel compelled to go along with it.
I agree, and that is part of what forms the case law around rape and sexual offense the statutes around the country, that it's not just physical compulsion or forcible physical compulsion, that there are certain factors like mental and emotional and psychological force as well that can and should be considered when we're considering the voluntariness of contact like this. Of course, an 11-year-old, I don't think by any state statute is of an age to consent, but those, again, emotional, psychological, even intellectual factors do come into play when we're talking about forcible compulsion.
Well, Marian Bracha, thank you so much. I really appreciate your time.
Thanks for having me. Happy holidays, Angenette.
And that's it for this episode of Crime Fix. I'm Angenette Levy. Thanks so much for being with me. I'll see you back here next time.